Hello, good evening, Assalamu alaikum. Welcome to Aman Sisters live stream. You're joining me, Basharat Ali, today. Just before we start the stream, just going to start with a couple of short videos. And there we go.
Aman Solicitors Advocates. Aman Solicitors Advocates. From our offices in London and Luton, we represent clients across England and Wales. We specialise in civil and commercial law and litigation, divorce, child custody, contact and family law, all areas of personal injury, accidents at work, trips and slips, family and business immigration, nationality, asylum, deportation and detention law, wills and probate, employment law for employees or employers, charity law and disputes, public and regulatory law. Our professional and committed legal team will provide you with a first-class and competitively priced service. Aman Solicitors Advocates, your firm of choice.
Thank you very much for joining us. Just to play the... Saad, Assalamu alaikum, good evening. Thank you for joining us. Today, you're going to talk to us about employment law and in particular constructive dismissal. So before we get into the detail, welcome to the live stream. Thank you for joining us.
Wa alaikum assalam. Thank you for having me.
Right. So tell us a little bit about what is constructive dismissal? What does this mean?
Okay. All right. Now, constructive dismissal is, in my opinion at least, quite a complicated area of law. And it's quite a complicated term as well. So when I tried to fully understand, at the outset of my legal career, what this actually meant, let me put it in the way in which I think the average person can understand. So
yes,
everybody knows what dismissal is. And, when you are either dismissed from your job or no longer asked to come in or made redundant, everybody knows what that is. Now, and it's very simple. And we talked before about unfair dismissal, which is where you challenge whether the reasons for dismissing you were unfair or not. So when we talk about constructive dismissal, we're talking about really a breach of contract. Okay, and that is really the breach of the employment contract that the employee will have with their employer. And what we mean by constructive dismissal is when one party, most probably the employer, has breached the terms of the contract in such a fundamental way that the contract is no longer worthy of being continued with, because it is effectively such a fundamental breach that it's the same as metaphorically tearing it up and not having it anymore.
There's a lot of law there. Can I just ask you, just stop you there for a second? So the average person watching, give us a couple of examples in everyday life, whether somebody works in retail, in an office, in something of that nature where constructive dismissal, they would recognize it when they saw it. Okay,
that's a very good point. So if we look at the average job situation, whether anybody has a written contract or not, or a verbal contract, there's always some kind of contract in existence. Okay, so if somebody was to go to their place of work, work from 9 in the morning till 5 in the evening, as is the norm in offices, do that for a whole month and then be paid at the end of that month, let's say a global sum of £2,000.
Right.
And we can say from that the contract consists of these terms. The terms are that the employer has to arrive and work between the hours of 9 and 5. He has to work, let's say, 5 days a week, Monday to Friday. And he would be paid £2,000 per month for doing so. Okay. So if the employer was then to breach a fundamental term of that contract. So the most fundamental term of this contract, which I've highlighted, is the pay. Let's say the employer turned around and said, okay, now I've made a decision. I'm not going to pay you £2,000. I'm going to pay you £20 for the month's work.
Okay, so to stop you there. So if, for example, salary is substantially refused, but you have to do the same job and you don't agree to that, on the face of it, that's constructive dismissal. So what about if I am employed as a receptionist and they say, right, you're going to become a cleaner now because we don't want you to become a receptionist. I want to get my friend to become the receptionist. So the post still exists and you're sort of unceremoniously thrown the mop and told, right, you're going to go and mop up and clean up. Would that be a constructive dismissal as well?
It could. Again, it depends whether it goes to the heart of the contract, because we are talking about fundamental breaches. Ordinarily, one would say yes. However, we have to look at the whole situation to see whether the request was a reasonable request or not, and look at the whole contract really to see whether that was a fundamental term of the contract. So many people have contracts of employment which specify their job, but sometimes they have a term within that contract writing saying that they may be asked to do other jobs as and when required according to operational needs. So if there's a term like that, then sometimes it could be asking a receptionist to clean up maybe their own desk or their office space may not be a fundamental breach of contract.
Right.
Okay, but
Okay.
if it was, then we're talking about a constructive dismissal.
So as an employee, I think I'm being constructively dismissed. What are my options? Do I tell the boss or the manager to say, look, this is constructive dismissal. If you don't stop this, I'm going to leave and then I'm going to bring a claim against you? How do I try and stop being dismissed? Just to remind the employer of the duty.
Yeah, okay. So if an employer is faced with a situation, if an employee is faced with a situation where they think the employer is not sticking to a fundamental term of their contract, then they have a choice to make. The choice is either to accept that, in which case, if they do, either verbally or by conduct or by not disagreeing with it, then the contract has changed and that new term comes into effect and becomes a term of the contract, and then you continue under the new terms. However, if the employee thinks, no, this is such a fundamental breach of my contract, my employer is not sticking to the contract and it's fundamentally changed, then their option is to mostly resign. Okay,
but you must resign by saying you have fundamentally breached the terms of my employment contract. I am now resigning because I've got no option. What we originally agreed has been completely, basically torn apart, and I'm leaving and I'm going to now sue you for breach of contract or constructive dismissal.
Effectively, yes. So yes, that's right. So the employer will say that, as you said, I believe that there's been a fundamental breach of our contract, and for that reason I am now resigning because you are forcing me to resign. You have acted in a way in which you have not given any regard to our contract. You've not given any importance to it. I cannot continue anymore. The contract no longer exists because of your behavior. I am therefore resigning. Yes. So when a person resigns in those circumstances because of the fundamental breach of contract, that constitutes a dismissal for the purposes of the law.
Employment law. And so as an employee, do I have a time limit to bring the claim? Do I have to approach, there's something called ACAS, which you always hear about. What do I do to preserve my position as an employee?
Yes. Okay. So obviously, if you decide to resign, then you can then bring a claim for what we call constructive dismissal, okay, which is a claim that your employer fundamentally breached your contract. So you have 3 months. So let's say the date of resignation was today, and today is the 22nd of March.
Yeah.
You have 3 months minus 1 day, so until the 21st of June, to contact ACAS and enter early conciliation. Okay.
Right.
And you must take this step if you are intending to later make a claim in the employment tribunal. Because if you don't take this step, if you don't contact ACAS, you cannot make a claim to the tribunal.
So I've done that. My employer said, I don't care. You're just making excuses. You're lazy. You're useless. I don't agree. Do what you want. So 3 months have elapsed. Sorry, I made the claim via ACAS. No resolution. What's my next step?
Okay, so once the early conciliation process finishes, ACAS will issue you with a certificate to confirm that you have gone through it and there's been no resolution. You have 1 month from the date of that certificate to make your claim to the employment tribunal.
Okay, so now here is what we need to understand. A lot of people say, well, it's only filling in a form. I just tell them what happened and my case is going to be dealt with. In your professional opinion, you've come across many cases defending or bringing a claim. What would you recommend to the average person, the average Muhammad, John, Dave, Sharon, Mariam, whoever it might be? Should they take legal advice if they can afford it at this stage, or should they just sort of go it alone and see what happens?
Well, obviously, it depends on the individual and how clued up they are. But I will say to everybody watching this video that the common pitfalls when anybody makes a claim for constructive dismissal is that the claim is not properly put within the claim form. And what do I mean by that? Well, what I mean is that the actual term of the contract which is being relied upon by the employee to say that the employer has breached has not been properly identified. Okay, and if the term of the contract has not been properly identified, it could be that there is no claim, because when you get to the tribunal, a judge will look at it and say, I don't understand your case. I don't understand the term that you're relying upon. And if I can't see what term you're relying upon, I can't see that you have a claim. And the worst case scenario is if the judge says, I can't see you have a claim, then your case can be struck out.
Struck out means that basically it will be defeated there and then. It won't be allowed to continue, and that's it. You've lost your case.
Exactly. So if anybody who thinks that they've been constructively dismissed wants to make a claim, it is very, very important that the claim is put properly within the claim form. And if anybody thinks that they need legal advice for that, it's highly recommended for them to seek that.
I mean, people sometimes get worried because they are naturally concerned these days with the fact that money is not easy to come by. Can you offer some sort of assessment service, you or any other solicitor, which would enable a professional person to look at the nature of the claim and to say, well, actually, you have got a claim, it's very good, or it's mediocre, or in fact, you've got no claim, and thereby avoiding unnecessarily wasting time and possibly money later by pursuing effectively a meritless claim? Is there something that can be done, like a fixed fee assessment or something of that nature?
Yeah, most definitely. Now, from our point of view, as you'll be aware, we offer a fixed price consultation at the outset, where a person can come to us and ask us exactly these questions. They can ask us, what do I need to do to make sure that my claim is pleaded properly? And we can advise them. They can ask us, how much is my claim worth? And we can advise them. And they can ask us, how much would you charge if you were going to do it? And we can advise them. And they can make a decision then, is it financially worth it or not? And they can also ask us, what do you think our chances are? And based on the information which we get initially at the consultation, we can always advise them. Then obviously the person seeking the advice or receiving the advice can make a properly informed decision whether they think it's worth proceeding or not.
Okay, I mean, just for argument's sake, somebody needs that advice. What are they looking at? Hundreds of pounds, £500? What would you charge for the basic sort of person, not something very complex or factually or even historically very murky? How much would you charge for a fixed fee consultation to get a handle of things and to give some basic advice?
Well, a general consultation, my charge would be in the region of about £120. That is for about half an hour, possibly 45-minute consultation, where I can get all the information I need and answer these preliminary questions that anybody may have.
Okay, so I've come to you, we've had the consultation, and you give me some good news that I've got a good case. What do we do next? I mean, how long will it take before I get before a judge and have my day in court, firstly, and then I've got a couple of other questions to follow up?
Yeah, certainly. So from the point that the claim form is lodged in the tribunal, unfortunately, because of the COVID pandemic at the moment, there are long delays within the employment tribunal system. So you're certainly talking several months before you get to the end, which is the actual hearing itself, where your claim is decided and determined. It could even be a year, possibly even longer. It does depend on a number of factors, such as how complicated your claim is, how many terms you're relying upon, the nature of the evidence and whether that is complicated or not, how many witnesses you may need or have. But the longer and more complicated your claim is, the more time the tribunal will need to determine it, and so the more time it will take for it to be resolved. If it is a fairly straightforward and simple matter, if the tribunal only needs a day or two to have the actual final hearing, then you could get a date within a few months. But depending on where you are in the country, because different tribunals have got different times and waiting lists at the moment.
Okay, so straightforward case. I mean, is there a chance that after I start my case, or you do it for me as a prospective claimant, that you could get a settlement without having to spend thousands of pounds of legal fees and what have you, and not to go to a trial? So if the case is properly, professionally, the word is pleaded or explained, and the other side realize that, you know what, John or Miriam are not messing around, they've got a firm of solicitors, they've got a person who knows what they're doing, you know, the game's up, I'm going to offer him a way out. I mean, is this something which is reasonably common, and is this something that somebody should factor in when they are looking at this?
Yes, most definitely. So let's go through a scenario just to explain. So let's say somebody came to me, and they're only claiming there was one term of the contract which had been breached, but I assessed the value of that as being, let's say, £10,000. So because we're talking about a relatively straightforward case, if the person was being legally representative, what the representative can do is make sure that that breach of contract is clearly explained in any claim form, so that when the employer receives it, they properly understand what is actually being claimed. And if they do properly understand what is exactly being claimed, and they know the exact amounts and the details, they can then make a decision. Okay, first of all, do we think this person is right or wrong? If we think this person is right because what they say is correct and the details are all there, then there's no need to defend this case or take it all the way to the tribunal, because we're only going to put off the inevitable, which is that we're going to have to pay out the money anyway. And in that situation, you would hope that the employer sees sense and makes an offer to settle, and therefore avoid the need for a lengthy or expensive claim in the tribunal.
Last two questions for now. In terms of the limits on damages, is there a limit on the amount of money I can recover if I succeed in a claim such as this?
Yes. So whenever you're claiming a breach of contract, then if you make any claim in the employment tribunal, the limit is £25,000. That's the maximum you can claim, even if your losses or the breach cost you more than that. If you want, therefore, to claim more than £25,000, if your claim is worth, let's say, £100,000, you may be better off making a claim in the High Court for a breach of contract instead, or the county court, but the civil courts instead. But obviously, the rules in the civil courts are different. Because it's a different jurisdiction, you have different rules, you have different risks there as well. But in the employment tribunal, it's up to £25,000 for a breach of contract.
Okay. And in terms of, obviously, I can't sit back and think, I'm going to win this case. I've got to try and find a job to try and mitigate my position, i.e. limit the losses to myself. Is that right?
Yes, that is correct. Mitigation of losses is always taken into account and is important, yes. So you're right. The person who sits back and does nothing and just lets the losses flow, a little bit like water coming out of a bottle, is not going to be able to recoup everything. Obviously, if I use that example, if the water comes out of a bottle, you're not going to be able to get all of the water back in. You're only going to get about 50% in. That's a good way of thinking of how much you could get in terms of damages. The more effort you make to find employment or to find alternative sources of income, the more likely you are to receive all of the losses that you incurred.
Okay, and final question, obviously at the first stage, if I lose, normally will I have to pay any costs to the other side, and could I recover my costs at the first appeal process? I mean, the Industrial Employment Tribunal, sorry.
Within the Employment Tribunal, there's generally no cost jurisdiction. However, the tribunal does have powers to award costs to any side if that side has acted what we call unreasonably, or if they had no reasonable prospect of success, or if they have acted vexatiously in bringing their claims. So what are we talking about there? We're talking about claims which really should never have been brought, or where one side acted very unreasonably in conducting the litigation, either by not following the rules properly or by prejudicing the other side. Some quite extreme behaviour. But if none of that has happened, then unfortunately, should you wish to recoup your costs, it may not be possible.
Okay, Saad, thank you very much for that. That's a very useful guide to a constructive dismissal claim. I'm now going to go to our colleague Rahil Latif. I hope he's available to talk to us about Priti Patel's favorite subject, asylum seekers, immigration and refugees. So stay with us for any questions at the end. I'm going to bring in Rahil and ask you to take some time in the green room. So there's Rahil. Assalamu alaikum, Rahil. How are you?
Alhamdulillah. How are you doing?
Very well. So yes, we're going to talk to you about Priti Patel's favorite subject, immigration and immigrants. So I'm a refugee, not very welcome, unfortunately, these days to many. I've arrived here and you've represented me. You've done a sterling job. You've got me refugee status or humanitarian protection, and I've got the 5-year visa. So now I've got to year 4 and 9 months. I need somebody to help me extend my visa or get settlement. So I come to you. What are you going to do for me?
Well, first of all, we'll just have to confirm when your leave does expire. Being 4 years and 9 months in is a bit too early to make an application, so we would advise the individual to wait at least a month before the leave expires. The key thing to remember now, everything is online, more or less, and so for those people in the worst case scenario, they can actually make an application on the last day that the leave is due to expire, because as long as it's in on time, i.e. on that day, then they'll be okay with the application. But yeah, that's the general thing. We'll look at how much time is left, when does the leave due to expire, and then advise on that basis.
I mean, it seems very dicey and ropey to wait until the last day, but I hear your point. Clearly, if you need to prepare a case, would you recommend somebody to come 2 months before their visa expires, 1 month? What's the ideal sort of scenario so that you're not rushing and sort of grabbing around for things at the last minute and, basically winging it on a prayer?
Yeah, I mean, it depends on individual circumstances, but about 8 to 6 weeks before the leave expires is 2 months before. That's an ideal time frame to assess the individual circumstances. There's a few factors that have to be taken into account when an individual is looking to apply for indefinite leave to remain as a refugee, and we just need to have a look at those circumstances and those factors, and to advise on that basis if there's any sort of pitfalls or obstacles that need to be overcome, and have time to advise on those points.
Okay, well, I've come, there's myself, my wife, and say 2 kids. Will I get legal aid automatically to cover my legal costs, first of all, or not?
Well, this is, I think, dependent on the assessment made by a particular solicitor who has a legal aid contract. A lot of the work can be considered to be form filling. However, because we are making an application according to the individual refugee status and under the Refugee Convention, there is legal advice required, which does then bring it within the remit of legal aid. And so as long as that individual is eligible from a financial perspective, then legal aid could be available depending on that individual's circumstances.
Okay, so you've looked at my pay slips and bank statement savings, I'm eligible. Now, what do I have to show? Do I still have to show that the reason I got my refugee status, or why I was successful, that danger or that risk to my life or my family's life still exists in the country I came from before I can succeed, or the historical risk is enough and I should be able to succeed in getting settlement or indefinite leave to remain?
Yeah, so we go back to when the law changed effectively back in 2005, when up until that point, refugees or individuals recognized as refugees were given indefinite leave to remain straight away. Then there was a reconsideration by the government at that time, I think a Labour government, and they decided that purpose of refugee status is temporary protection, and that's why they brought in the 5-year leave to remain. And then after 5 years, they said, well, we'll consider the individual circumstances, both in terms of the risk that they perceive they had when they left their country of origin, and any change in circumstances in that country of origin, and see whether or not that individual continues to be in need of refugee protection. So it's
not merely filling in forms. It needs a solicitor, ideally, or somebody who knows what they're doing, to explain to the Home Office and provide supporting evidence, corroborating evidence that, the situation's either got far worse or it's still the same, and therefore I cannot go back to where I had to flee, and then asking the Home Office to grant the person and their dependents, if any, settlement or indefinite leave to remain.
That's right. So there is a need to assess the individual's reason for claiming asylum, and then to consider whether or not those circumstances still exist, whether it was there's been a change in the country situation. So, for example, we currently, unfortunately, have the ongoing situation in Syria, and it's been 10 years now. So now the country guidance on that would say anyone who's perceived to be opposed to the regime, there will be at risk, and this also applies to those individuals who are failed asylum seekers originally, if they've come to the UK as students. And so there's a situation where that at the moment, that for Syrian nationals, the situation is persisting. But the Home Office do reserve the right to review cases and to call individuals back in for interviews to get further information regarding their particular circumstances. And there are other factors that will also take into account as well.
Right. So typically, what would you just sort of list a few factors that you, as a professional dealing with this sort of work, will look at in any given case so people can understand what's involved?
Yeah, so taking the individual, first thing I would want to consider is whether or not there's been any criminal offences. That's an important point. If there is a criminal offence, depending on the severity, if there was a custodial sentence, this will have a direct impact on whether or not the individual is going to be eligible for indefinite leave to remain, or whether if there is a custodial sentence for a short period of time, then that would probably lead to an extension of leave rather than indefinite, even if they meet the other criteria. And if there's non-custodial sentences, you've got to look at those circumstances as well. So that's the first starting point, any criminal offences. Secondly,
right,
then you've got, yeah.
Sorry. Yes, thank you.
After you.
Second, yeah, just carry on. Secondly.
Okay. Secondly, there's an issue about the individual's travel history. So we have to see whether or not they've travelled abroad, where they've travelled, how long that a single journey may have been, whether they've travelled particularly to their country of origin for any particular reason. And we've had situations where, for whatever reason, an individual has had the need to travel to that country where they claim asylum from. And we have to look at those factors, because if the Home Office is aware of it, obviously, and any individual who's filling in a form should be, upfront with all the correct details, then there might be a legitimate reason which the Home Office will consider and not hold it against the individual when they're applying as well. So that's important, again, to look at that, because that's one of the key questions within the application.
Well, let's say I came from country X and there was a horrible ruler in country X when I came, and my people like me were being persecuted. But now somebody from my tribe or my background is in charge, and they're persecuting the other side. So what's going to happen to me when I apply for SETM and say, I just don't want to go back? I've got kids, I've been here, I'm working, and the situation is not very nice, but it's not bad for me as a family or because of my tribe or my political background. What happens there?
Well, I said the Home Office will look beyond the individual's initial claim for asylum to see if there's any other reasons why they fear returning to the country. And there could be a change in circumstances. There could be issues that have arisen which were not present at the time the individual claimed asylum, in terms of their country situation or their own personal situation in their home country, country X. Then the Home Office will look beyond that and look at their circumstances in the UK, their established roots, they've got their family life. And these are key considerations the Home Office have to make, particularly if there's children involved and may have been born in the UK or may have come here at a very young age and 5 years have gone past. And so these are factors which the Home Office will take into consideration. To date, I have to say that the Home Office, from my experience, hasn't called an individual back in for an interview, and very few number of individuals have been refused this application. It's unclear why the Home Office take the view, but it could be that from a procedural or policy position, it might be very difficult to exercise any further step in this matter. There have been few cases recently where the Home Office have delved deeper into an individual background and have taken further action in terms of revocation of refugee status. But that's can get quite complicated for today.
No, we'll look at revocation separately in the coming weeks. So, I mean, given that Ms. Patel has been talking tough on asylum and immigration, we may have to do a special program about this separately, but it would be wise to get professional advice, whether on public funding, legal aid, or if you have to pay privately, to make sure that you put everything in, because if you're refused, you're going to fall into the process of appeals and challenges and the headache and the limbo that comes with it, right?
That's right. Yeah. So it's important to get advice. So we always suggest that on our shows. But it's very important because, again, if you fail to disclose the material information but still are granted yet at a later date, particularly if you're applying for naturalization and it's then raised at that point, then the Home Office won't waste any time to raise the issue of deception. And that will then impact upon any individual's right or wish to claim to apply for British citizenship in the future as well. So it's important to get advice, look at all the issues that are relevant to the application before making the application itself.
And how long does it take? Let's say everything's fine, I've come to you, you've done a sterling job, prepared an application. How long is it taking to turn things around nowadays? I mean, from applying from today, would it be months, years, weeks?
Well, it varies. COVID hasn't really impacted that much on this process. There were applications that were outstanding prior to COVID that did get caught up in the COVID backlog or delay. But recently, we've had individuals making the application, and I think roughly looking at 4 to 6 months. I mean, I had one individual who got a decision within a week of submitting their biometrics. So the application process from submitting the application online, booking the biometric appointment, and getting the decision was 6 weeks roughly. So it could be as quick as that.
And obviously, if a minor came, final question before we go to our colleague Adnan Mahmood, if a minor came to the country and they were given 5 years and they're still a minor when they're applying for indefinite leave to remain, will there be any difference in the process, or will it be simply getting from, how would that work in a nutshell for settlement?
No, I think from my understanding, there'll be no real difference in the process for the settlement application. However, if they're still a minor, I think there'd be even more leeway or in terms of the favor of that minor. So as far as from my reading of the guidance, there isn't any difference in the approach taken by the Home Office in terms of the process itself.
And the very final question, is there a fee to pay? And do you have to provide any other documents like English language certificates, knowledge of life in the UK, life and living in the UK? Sorry, does any of that apply?
No, so at this stage, there is no Home Office fee, and there's no requirement to have the Life in the UK test or English language requirement, which will apply when the individual does apply for nationality at a later date, but they're not requirements for this application. Perfect.
Well, Rahil, thank you very much for sharing your wisdom with us. Our colleague Adnan Mahmood is, I think, available. I will just have a quick, yes, he is. So I will ask him to join us, and I will ask you to enjoy yourself in the green room, and we'll go on to Adnan's feature. Assalamu alaikum, Adnan.
Wa alaikum assalam. How are you?
I'm very well, thank you. Thank you for joining us. I will ask Rahil to take a break. Where's Rahil? There we go. He's gone. Oh, that's much better, right? There's two of us. Three's a crowd, as they say. Right. So, injunctions. Last week, you told us about what I should do if I have been duped, robbed, conned, whatever the word would be, out of money, whether in business or whether in my personal life. Now, let's flip it this week. So, I'm the businessman, and I've been duped. I've just realized that the injunction somebody's got against me, they've got by either being dishonest or not being completely honest. What do I do? My business is paralyzed. My stock is frozen. I can't sell my car. I can't get access to a business bank account or personal bank accounts. What do I do?
Well, in the first instance, what would have happened is that with the applicant who would have applied for the freezing order would have had to have served a copy of that freezing injunction on you. Yeah. Which by serve, what I mean is that you should have received a copy. If you somehow find out that you can't access your bank account because it's been frozen and you haven't been served with a copy of it, then that raises serious procedural concerns as far as the applicant is concerned. When I refer to applicant, I'm referring to the person who's obtained the order. You, in legal terms, would be referred to as the respondent. So if that's the case, then if you realize that your accounts have been frozen, then obviously you need to make inquiries with the bank and find out what the issue is. If, however, you have been served with an order, an injunction, it will have on it a hearing date. It's known as a return date, which is your opportunity to return the matter to court and put your side of the story. So remember, if we discussed last week, an applicant can obtain what's called an ex parte order, which is without notice, without even telling you, because they might have told the judge that if they alert you to the fact that there is a need for an injunction, then you may well be tipped off, and you might dispose of those assets without.
I understand.
Sorry, I'm not sure if you caught that because my screen froze for a moment there.
Mine is definitely not frozen, so I think we're having a little bit of a technical problem again. It's that gremlin we had last week. I think we need to freeze that gremlin somehow, or defrost it, because you're still frozen. Can you hear me, Adnan?
Yeah, I can hear you now.
You're still frozen on my screen. Okay, let's...
as we said, quite ironically, given that we're talking about freezing injunctions.
Yeah, it's definitely an irony of sorts, for sure. Quick question then. I've given you all the documentation, the dates in 4 days' time. What do you need from me? Obviously, you'll need money. You'll need the paperwork. How quickly can this be done? And do I have to pitch up at your office? Or can we do a lot of this work remotely?
Well, I think given the outbreak of the COVID pandemic, a lot of work can be done remotely. A lot of solicitors' practices have adjusted to work remotely as it is. I myself have done a number of applications of a similar nature remotely. And more than likely, such a hearing in the current climate would be listed remotely as well, i.e. by video or by telephone. But anyway, assuming that you've given me the papers and I can see that there is a hearing date, the first thing I would need to do is get your side of the story.
Okay.
What's your version of events? Is what the applicant has said true or not? If it's not, and it's all a load of lies, then it's important that your version of events is documented and put before the court. And ordinarily, we would do that by way of a witness statement from you. Make sure that is given to the court in advance of the hearing, so a judge can properly read and understand what your side of the story is, and then take a view whether or not there's a disputed fact. And naturally, you'd require attendance at the hearing where your side of the story is put to the judge, and the judge understands that the matters are disputed, and try our utmost to have the injunction cancelled.
Okay. Well, let's say there is some truth to the allegations against me, and I'm struggling to pay the rent, take some money out to put a roof over my family's head. How can I try and get enough expenses, enough money to keep my business going and to be able to pay my way? What do I have to show to a judge to convince them to say, relax? Because the judge said, look, I think Mr. Smith is right. You've sold them some dodgy goods, but I'm not so sure that you're so dodgy, I should starve you out of your house. What do I have to show?
Well, any freezing injunction which seeks to freeze bank accounts usually has a provision within it that you are allowed reasonable living expenditure. And a judge hearing the case who would have granted the application would have more than likely stipulated a figure of how much that is. Now, if that's not enough to meet your needs, then it's important at the hearing that the judge is advised that you require more. Ideally, a statement of means should be prepared so that a judge can see what your outlay is, what are your outgoings, and then based upon that, then it will be pleaded for the judge to extend or increase that amount to allow you to meet those expenses.
Will I need to establish if I've got unusual expenditure, which is quite high? Will I have to provide pieces of paper, documentary evidence, like this is how much I pay every month? Say my kids go to a private school. Let's say, we need some specific diet. We have specific dietary requirements where I have to buy special food for a member of the family, and it's hundreds of pounds a month or more for such a person. Will I be able to just say, well, Judge, I want £4,000 a month because I shop at, Waitrose or wherever else? Or do I have to provide proof if it's going to be unusual expenditure?
Well, you can try and argue it without any proof, but you probably won't get very far. In courts, you must be able to prove your case. So and that is usually, evidence is provided in the form of bank statements, in the form of invoices, whatever expenditure it is that you're trying to meet. A judge needs to be able to see that. It's rare for a judge to go to base a decision purely upon your say-so, especially if it's disputed by the other side. They may say, no, this is nonsense, and you haven't provided any what we call corroborative evidence.
Okay, so we've got to the court again. We managed to get me enough leeway to keep going. Now, obviously, Mr. Smith wants his money, and I'm saying, well, actually, no, Mr. Smith was told that this is a job lot, and some of the goods are not going to work, and some are going to work, and therefore, he's just basically being a bit naughty, or whatever the allegation is going to be. Now, if it's going to go all the way, I'm assuming it's going to cost a lot of money in the High Court, for example. What could you do to try and settle this case without having to go to court if I'm part to blame, but not wholly to blame?
Well, a lot of that comes down to tactics of how tactfully we argue your case. So I'll give you an example. If, like, for example, you're saying there were certain facts which the judge may not have been informed about at the first hearing, where you weren't present. I don't know if you recall from last year, we discussed the issue of full and frank disclosure. It's the applicant's responsibility, if they are obtaining an injunction without notice to you, that they appraise the judge of the full facts. And if they haven't, so say, for example, they've only appraised him of half of the terms of the agreement between you and not the other, or any items of correspondence where you've made clear that some of these items might not work, etc., then what you can do is present that to the judge and show to the judge that the applicant failed in giving full and frank disclosure. And even on that basis alone, sometimes an injunction can be cancelled, can be dismissed, and the applicant can be ordered to pay costs. So this is one form of attack that can be used. The applicant would have to be, their advocate who would have represented them at the first hearing, has to provide what's called an advocate's note. Yeah. So what they would have had, they would have prepared the application with an application form together with a witness statement, but then certain representations may have been said at court to the judge, which you're not aware of.
Right.
They are duty bound, their advocate is duty bound to prepare a note, and that must be served upon you as well, so that you are fully appraised of everything that was said to the judge, and you then have your opportunity to respond to it. And if full and frank disclosure hasn't been provided, then you would use that. So that's one form of a tactic. Another is obviously, negotiation always helps. Negotiating with the other side, entering into dialogue, whether it's the parties themselves or through solicitors, where we show the other side the weaknesses in their case and the strengths in our case, and then invite them to reach some common ground so that each party can save on, legal cost and avoid taking the case all the way to trial. So yes, it would be extremely important to try and settle.
Now, in terms of so what you're saying is that people have to be realistic and pragmatic, and not start being hard-headed and dogmatic and just sort of no, that's it, it's all or nothing. Because quite frankly, if you end up going down this rabbit's hole, you could end up getting lampooned at the end and pay a lot of cost, perhaps even sometimes more than what your claim is worth, if you are unreasonable and not being, realistic. That's what you're saying, right?
Yes, both parties have to be realistic, and in fact, it's the legal advisor's responsibility to ensure that their client is provided with proper, sound advice, where they are fully aware of the strengths and weaknesses of the case. If it's a weak case, as lawyers, we're legally obliged to inform you that your case is, to be frank, rubbish, and it's not going to get very far, and that there's a risk of you getting smacked with costs.
Right. So, in terms of the discussion, you moved on. The client says that I don't want any of this sort of trimmings. I don't need all of this advice. I want to give you the minimum amount of money. You just fill in some forms for me and get me out of this mess. Now, clearly, costs are linked to time. And you, as a professional, would you be willing to go down this sort of cherry picking of what they want you to talk about or not? Or rather, would you say, no, hold on, it's a very serious matter here. Here are the likely costs based upon the evidence, based upon the documents, based upon my time. Either you want to fund it properly or politely jog on.
Well, perhaps if I give some
Looks
kind
like-
of a medical analogy.
Yeah,
If
anyone's.
if a doctor tells you that both of your kidneys are failing and you need to have both of them removed, and well, you need a transplant on both of them, it's highly unlikely that you're going to say, I'm a bit short of cash, doc, can you just do one? I'll save up and we'll do the other one another day. No, you need to be fully aware of the risks and the costs involved. No cherry picking will only be disastrous for your case. The lawyers work in the same way. We can't just pick and choose of what parts of your case to focus on and what not to. You need to take it as a whole, so that, because at the end of the day, it's the judge will consider the case as a whole.
Okay, and in terms of, because obviously, as you said, these are normally linked to disputes about of substance regarding a contract, a sale, a purchase, and there, if you are able to deal with it yourself as a solicitor advocate, clearly that's a very attractive proposition to a client, because there's no added cost of a barrister, an extra layer of cost, which would usually be the case if a solicitor who wasn't an advocate, did not have trial experience, was instructed. And what would you suggest to clients? To shop around, to look around, get prices, get some idea of experience as well, because ultimately it's all very well having a solicitor advocate who spent his entire life in the criminal courts, doesn't really know, to use common parlance, a Scooby-Doo, about injunctions and civil proceedings. Trying to sort of wing it would be very destructive, right? So the client should be aware of who they're asking to represent them.
Again, using
Aman?
a similar medical analogy, you wouldn't ask. Yeah, sorry, can you hear me?
Yeah, I can. Sorry, you're frozen, but I can hear you.
Can you hear me?
Yes, I can hear you.
Again, using a similar medical analogy, you wouldn't ask for a practitioner, a GP, to carry out brain review. You'd need a proper brain surgeon in order to do so. So, by the same token, if your case requires some form of legal expertise, it's important that you get that legal expertise. You don't, select somebody on the cheap just because they've had they've done a little bit of that work, but not a great deal of it. Because you want somebody who fully understands procedure, who fully understands the law, and not only that, has the experience to advocate your case before a judge. So it is important to shop around in order to obviously get yourself the best deal. And if that does mean that the solicitor who you instruct doesn't have trial experience, but he now has a barrister who he can instruct, who can assist you, then that may be the best option. Alternatively, if you have a solicitor advocate who can take your case by the horns and deal with it as a solicitor as well as an advocate in court, because they have that requisite experience, then that might be a better option. Obviously, that's for the client to weigh up all of the relevant costs and facts and experience and make a decision from there.
I mean, you just sort of give us a minimum. It's difficult to predict, but let's say it's, relatively speaking, not that any of such cases is straightforward by its nature. If you're going for emergency injunctions, there's all sorts of complexity. Are we talking tens of thousands of pounds to get an injunction, thousands, hundreds? What is it to get the ball rolling? Obviously, the detail of the case, that will depend, and it may well be many tens of thousands or even perhaps more. But in the beginning, when somebody's literally been numbed or dumbstruck by being given an injunction, everything frozen, what are we going to be looking at before you will get the ball rolling, so to speak?
Well, like you said, it all depends on the case. I mean, it could be a case which involves multiple defendants. I mean, it might not just be you. You might not be the only one who's had your assets frozen, or you're some kind of injunction served.
I see what you mean.
Maybe you and your pals. So everything needs to be looked at in terms of volume. Solicitors and barristers, they all work according to time involved. So if it's if it's a simple case, so if I give you just an example, if it's just a simple case, say one bank account which has been frozen, and it's a standard breach of contract claim, for example, then you'd be looking at maybe about $1,000, $2,000 at the return date for a barrister or a lawyer solicitor to get fully up to speed with the facts, perhaps prepare a short witness statement in response, and then pitch up and represent you at the hearing. But if it gets messy and the trial, the matter continues as disputed facts, and a judge says, look, I can't decide all of this today, I will need to hear live evidence from everyone, and then the matter gets listed for a trial, then there'll be more costs. And that also depends on time involved, because the case might be 1 day in court for a trial, could be 5.
Understood. So to conclude then, clearly these are complicated and very difficult matters which affect people's personal lives and businesses and so on. So the take-home advice is make sure you find somebody who's experienced, competent, and able to do the job, and if necessary, willing to work late into the night, on the weekend. Get all this clear first. The last thing you want to do is put the money into the account of a solicitor, come 5 o'clock on Friday, sorry, pal, time to go home. I'll see you Monday at 9 o'clock. In the meantime, go down to the local, soup kitchen or food bank and help yourself, because I'm really busy. I mean, you want to clear all these things up before you actually get someone to do that.
Quite right. Yeah, quite right. Capacity is important. It's important that you discuss, if you're served with an injunction, that you find out from any lawyer that you instruct, look, do you have capacity to deal with this? Because injunctive relief work is very time consuming, and it does dropping what you're dealing with and putting all of your focus on the injunction itself. And that does involve, perhaps in some instances, working late into the night, working over the weekend, preparing the case and getting it ready. So it's very important that you have that discussion with any lawyer to find out, can you deal with this? And only then, if a lawyer says, yes, he can, then move forward.
Right. So thank you very much. I'm going to add everybody back in, and I think we're going to just call it a day. So welcome back, Mr. Saeed, and welcome back, Mr. Latif. It's nice to have you all. Thank you very much, gents, for joining us and sharing, as ever, your expertise and experience. For all it remains for me to say is thank you very much to all of you for taking time out this evening, and Assalamu alaikum and good night from me.
Salam.
Just bear with me. We don't want any of those famous outtakes, so I'm going to end the broadcast now. So I've got to play a short video, which would be a disclaimer. As always, the discussion today was general. Please do not act upon this, because we will not be liable. Nothing like solicitors giving you a disclaimer before they conclude the show. So just one quick video and then we'll be out. It's goodbye from all of us.